Hello, everyone. I'm Evan Schwartz, lawyer, law firm owner, and someone who's been spent over 35 years practicing law in both New York and in jurisdictions all over the United States.
And I'm Matt Conroy. I've represented people in jury trials, bench trials, and different types of litigation for over 30 years up and down the East Coast.
Welcome to Ask the Lawyers, the podcast where we answer your legal questions, no matter how big, how small, or how complicated.
We're here to explain your rights when it comes to being questioned by the police, taking phone calls, any kind of legal minutia, no matter how big or small. We're going to break it down for you in simple terms.
Could be divorce, could be landlord-tenant. It could be anything that you feel isn't fair or you haven't gotten an answer to and you didn't know where to go to for the answers. We're going to answer those questions.
And we're not going to stick to our specialties. Anything that's of interest to you is of interest to us. If it's legal, we're going to talk about it.
So think of this podcast as your one-stop shop for legal clarity. We're going to answer your questions and hopefully give you some guidance to where you can go next with your legal problem.
Enough with the intro. Let's get down to it.
Okay, but before we start, we have to read the disclaimer because we're rendering advice for entertainment purposes and not your lawyers. So the information provided on this podcast is for entertainment purposes only and does not constitute legal advice. Please consult with a licensed attorney in your jurisdiction regarding any legal matter you may have. Watching this podcast does not establish an attorney-client relationship with any of the attorneys featured on the podcast. And with that, let's get started.
Is a verbal agreement legally binding, or do I need a written contract? Matt,
you take that one. Will do. So the question is whether or not an oral agreement is enforceable, and in the state of New York and most states, it's enforceable under certain conditions. The issues that arise with oral agreements is whether or not it's barred by the statute of frauds. The general rule is that agreements have to be in writing unless they can be performed within a year, and then there are sort of hard and fast rules that if it involves the sale of real estate or certain other types of transactions, those must be in writing. So the answer is sometimes. But good advice would be that if you're going to have an agreement about something important, you probably want it to be in writing.
Yeah, because at the end of the day, these days with all of the messaging and all the social media and all the ways you can communicate, you could just send an email, and an email could be a contract. You know, I'm going to remove all the stuff from your garage for $1,000 on Saturday. Okay, I look forward to seeing you. Good deal. You have a contract. It's in writing. It doesn't need to be some formal document that some lawyer cooked up in their office. We would recommend, hey, get a writing. But under the circumstances, Matt says, many of those deals, like the garage that I just described, that would be enforceable without a writing. But rather than have to deal with the problems, just confirm text message, email, probably not a snap, maybe an Insta message, but yeah.
The story of how the American statute of frauds was born, though, is pretty fun. And I'm massively paraphrasing, and I'm probably going to add some literary license to this. But essentially, two guys who were neighbors went out drinking at a bar, got completely hammered, and they basically came to an agreement that drunk guy A would sell his property to drunk guy B for $1,000. And 2 days later, drunk guy A says, "What are you talking about?" I don't remember that at all. Drunk guy B said, "Come on, clear as day." They had a little piece of napkin, some scribble on it. Drunk guy B sues drunk guy A. Court looks at it and says, this isn't a great situation. You don't really remember. You don't really remember. So let's just make a rule. When it comes to real estate and selling big items like that, got to have a signed writing by both parties. So the statute of frauds ultimately sort of was born by two drunk guys in a bar.
And apparently whatever they scribbled on the napkin was not sufficient to inform anybody on the enforceability of the agreement.
Yeah.
A story I've never heard, but I like that one.
Yeah, I'm not sure it's completely true, but I think there's some elements of truth to it.
Okay.
can an insurance company cancel my policy after a claim?
Well, depends on what kind of insurance policy you have. If your policy is in force for a particular period of time, which most, let's say, automobile policies, homeowners policies, business insurance policies are typically 6 months or a year. And so if you have a policy that's in force, and even if there's a claim, the policy is still in force for that period of time of the contract. But at the end of the contract, the insurance company can say we're not renewing. Otherwise, they can't just cancel it. Now, if they say or think, hey, you committed fraud, they can, in many circumstances, void those types of contracts. But other types of contracts like life insurance, disability insurance, long-term care insurance, those in the industry, they call them non-cancelable as long as you're paying the premiums. So in those, they can't cancel them almost under any circumstances. And life insurance, after 2 years, they're stuck with it for as long as the contract reads. They can't just cancel it. Other times on those policies, they may be able to get out of it if they think you lied on the application of insurance and seek to what they call rescind it, because they say you lied on the application. We never would have sold you this policy had we known that when you signed up for life insurance, you were stage 4 cancer and given 30 days to live. We would not have given you this policy. They can get out of it. But generally speaking, for the period of time that the contract provides for, the insurance company cannot cancel it just because you make a claim.
What should I do if I receive a subpoena or a target letter? Should I comply?
If you get a grand jury subpoena, a subpoena from a plaintiff's firm or a defendant's firm in a lawsuit, you should consult with a lawyer. That's the first thing you should do. There are a lot of rules that go into compliance with a subpoena, whether or not it's too broad, whether or not the time range is too long, whether or not it's reasonable for the needs of the case. These are issues you could probably figure out, but probably wouldn't be worth your time doing. So when you get a subpoena or you get a target letter from, a government agency, seeking counsel is 100% the first thing you should do.
Yeah, and don't call the number at the bottom of the subpoena, decide whoever you're talking to seems like a nice gal or a nice guy, and you just wanted to tell them the facts and the truth. When you do that, you're giving up some of the most important and very few constitutional rights that you actually have to protect yourself, which includes the right to remain silent and the right to an attorney.
In a civil context, if you receive a subpoena, oftentimes you have a very short window to raise objections to the subpoena. And if you don't raise those in a timely fashion, they're waived. So when you get a subpoena, don't wait until the day that it's due to call a lawyer, because in many cases, even though the time to respond to the subpoena hasn't arrived, the time to object to it has. So it's important to do it timely.
Right. So when you get served with those types of things, don't mess around. Don't procrastinate. Consult with someone, generally a lawyer, who is qualified to give you advice on what you should do next.
But as Evan said, sometimes on these subpoenas, it says, if you have any questions, call, lawyer, I'm going to crush you at this number. Not a great idea. Call someone other than him or her.
Agreed.
How long does a business lawsuit typically take, and what are the costs?
That is the great unknown. How long does a business lawsuit take, and what does it cost? That depends on so many different factors. That what state are you in? How busy is the court system? How busy is the judge assigned to your case? Does the person you're suing have a lawyer that just wants to run the meter and bill up the file and fight on everything and delay? Does something weird happen during the case? Did somebody important in the case die? There are so many different factors. And that's why it's hard for a lawyer to say, hey, if you want to sue X, Y, and Z, or you're getting sued by somebody, I can tell you it's going to cost you X. Because you just don't know. You don't know what the other side's going to do. You don't know what's going to come up. You don't know how the court system is going to act. It is really, really difficult. So the best thing you can do is make sure that you have an adequate explanation from a competent attorney as to what's going to happen and what's kind of unpredictable.
We have cases in state courts and federal courts all over the country, and the range of time that a civil case could last could be months, could be years. We have cases that lasted almost 20 years in New York Supreme Court for a variety of reasons. But most clients at the initial meeting, those are two of their three questions, right? How long is it going to last? How much is it going to cost me? And what's the result going to be? Those are the big three. And all of them are difficult to answer, but at least knowing what court you're in, who the judge is, who the adversary is, what their history is, and what's involved in the case informs a little bit as to how long we anticipate it should taking. But again, the question of how much it's going to cost with hourly work, the length of days, months, or years that the case lasts has a direct relation to how much it's ultimately going to cost. The longer the case goes, the more expensive it's going to be. It's just the way it works.
Right. But think about this for a second. You filed a lawsuit or you were sued in 2019. What happens in 2020? The COVID lockdown. What happens after that? The courts shut down. What happens after that? They ultimately reopen. What happens after that? They're backed up beyond all your imagination. So those cases took twice as long, if not longer, and some of them still aren't over. That doesn't mean that every case that walks in the door is going to take 20 years, 5 years. Generally speaking, if we file a lawsuit, I tell clients that you're looking at maybe 18 months, maybe 24 months, depending on, are you going to trial? Is the case going to settle? Is it most likely to settle? Is it going to be resolved on a motion without having to go to trial? And those benchmarks can really have an impact on how long it's going to take.
You know, if you're consulting with a lawyer and you're not getting the answers that you want, understand it's just part of the system. And I've had people say to me, look, if I went to buy a house, new construction, and I met with a builder and I said, how long is it going to take and how much is it going to cost? And he basically said, oh, it's really hard to say. You know, there's a lot of things that could play into this, and it could take 6 months. It could take 6 years. It might cost you $500,000. It might cost you $5 million. You would walk away from that with fire burning in your shoes. I mean, nobody would put up with that, but you know, it's a different kind of transaction, and lawyers who work in specific types of practices get a good sense, depending on the court and the time and the type of case, how long these things take. Obviously, when COVID hit, it threw a monkey wrench into everything, which is still there in some ways. There are still courts that have log jams that have lasted since 21, 22. But again, if you don't like the answer, you could seek other counsel's advice. But sometimes there's just not a great answer to that question.
Can my insurance rates increase if I file a claim?
The short answer is, on the existing contract, they're not going to go up. But when you renew your contract, it is likely that they're going to evaluate how much money they had to pay out on your loss, and that will impact your premiums. Now, there are so many other things in the business of insurance that impact premiums, right? My general rule for me is if I bought insurance and I have a claim, I make the claim. I don't say I'm not going to make the claim because I don't want premiums to go up. I bought the insurance to cover my loss. So from a personal perspective, and my general advice to most clients is, you have the insurance, use the insurance, because premiums aren't just based on the amount of losses that occur. They're based on market conditions. They're based on how the insurance company is doing financially. They're based on the state regulatory agencies that regulate what they're allowed to charge at times. So there's so many different factors. The other thing I would say is it's also, what market are you in? Okay. Are you a construction company in New York that has a lot of employees who fall off ladders and scaffolds where it's really hard to get insurance? So depending on the industry you're in, that can also impact how hard it's going to be for you to get a policy and how much it's going to cost.
Yeah. In the event that you file a claim with a carrier on renewal, you're going to either go to a different carrier or file a reapplication with the same carrier. It's really important to list your claims because they're going to know anyway. So the idea that you are going to not list a prior claim in order to try to get a lower premium, you are going to put yourself in a rescission position and potentially be paying for insurance that has no coverage anyway. So being truthful on insurance applications is pretty critical.
Yep. There's little situations that can come up in this life on insurance where I know people have done certain things. For example, your daughter, who's the new driver, who's 17 years old, gets an offender bender. What a shock. Or son. And it's $785,000 in damage to the car. And you just decide to quietly give the person who your kid hit $785 in cash. I'm not saying to do that or not do that. I know that it happens. The only thing I would say, if you're going to do that with another driver, get a release, get a written release to protect yourself.
Do debt collectors only have a certain amount of time to sue for payments?
typically you have a 6-year statute of limitations on contract claims. And most debts, whether it's credit card or revolving credit type debt, fall into the 6-year window. So what ends up happening is if it's an installment contract or it's something that you're paying on a regular basis, the statute tends to run from the time that you last made a payment. So with credit cards, for example, or with a bank loan, if you stop making payments, you get demand letters, a year goes by, 2 years goes by, and then you make another payment, that restarts the clock on the statute of limitations. So there's a 6-year window here, but just be sort of wary that, and I'm not saying that you should not pay your debts. You should pay your debts. But just understand that when you're, if you don't make payments for 2 or 3 years and you think, if I wait 3 more years, the claim's expired. That might be true. But if you make a $20 payment 3 years into it, you're going to restart that clock.
Right. And just know about the timing is it is a creature of state law. So the claim for breach of contract varies in duration for statute of limitations by state. 6 years is New York. There are other states that are 5 years. There are some states that are 4 years. I don't believe there might be a state that's 7 years, but know what state you're in because that state law is going to govern the length of time. And that's different than a judgment. If someone goes after you and gets a judgment, that's going to last for a lot longer than the time for the creditor to go after you under the breach of contract statute. Judgments typically last 10 years or longer.
20 years.
Depending on the state that you're in. Again, so in New York, it's 20. In other states, again, it can vary. So,
and that can be renewed when the 20-year period comes up. The creditor can file to extend that.
Right. So when it comes to debts, last payment made, know your state law, and understand the difference between a claim under a breach of contract claim and a judgment against you.
I'm a business owner. Can I enforce a non-compete or non-disclosure agreement?
The answer is yes, but there have been recent rulings by the federal government that certain things can no longer be enforced in the world of restriction against competition. So you're going to have to consult with a qualified lawyer in the employment space to say, what can I do in terms of restricting this salesperson from leaving my company, going down the road and competing? Am I in an industry that's still protected? What is the geographic restriction I can put on this? And what is the length of time I can put on it? And that's obviously important to know for everybody's business because it affects the value of your business. And again, you've got federal rules and you've got state law that you have to contend with. So you really need to know from a qualified attorney what the rules are as it applies to your industry.
When you do employment agreements, most employers have one set template that they have all their employees sign. And you see this especially where you have companies that have vendors and clients and customers, you end up with lists. And as a business owner, you spent years developing the network of people that you buy things from and the network of people that you sell to. And having people come in that you're paying that then take that information and form a business down the road to compete with you, obviously it seems offensive to the person who owns and operates that business. But two of the issues are the geographic radius around your business that's enforceable, and that's different even within the same state. In New York, Manhattan is different than Brooklyn, is different than Albany or Geneseo or Buffalo. The denser the area, the smaller the reasonable geographic radius that it becomes enforceable. Similarly, the amount of time that you're going to try to restrain someone from being able to compete. The federal government essentially said, look, we don't like the idea of having private employers hire all these people and then have enforceable contracts that say you're not allowed to go out and start your own business. We want to encourage people to start their own businesses, not necessarily to poach your clients or to open up across the street. And that brings up the sort of reasonable time and geographic distribution area for it. But the general idea that a private employer can stop another American citizen from opening a business and competing with them, there are antitrust and sort of anti-competitive sentiments that work against that.
Right. And there's a big difference between competing down the road and doing underhanded things like before you leave the business, soliciting the customers to come with you. That's different than competing and going out and opening your own shop. That is something that can always still be viewed as a violation and can create an enforceable claim. You can't engage in sneaky, underhanded activities, okay? Stealing customer lists, soliciting before you leave, things of that nature. So there are still things that can be restricted, but you just have to be, again, that's why it's important to consult with someone that understands this area of the law.
And look, there are an endless number of litigations out there between companies and their former sort of top alpha salesperson, where the client develops a relationship with the salesperson, they leave, whether they open their own business or just go to a competing business that's already existing. Clients tend to follow the people that they work with. And it may, on the face of it, appear as though this salesperson poached the clients of his former employer, but the reality is the client has some say in that as well. And you see that with lawyers, you see that with salespeople, pretty common. But whether or not it's an actionable claim, that's what discovery reveals, and whether or not somebody had gone out and copied a database drive and you have all these emails and, phone calls that evidence solicitation, that's a little bit different than, conversely, if you have all these emails from the client saying, hey, where did you go? Or phone calls to the company saying, we really like Brian. Where did Brian go? So these cases tend to be somewhat fact sensitive.
Agreed.
Should I talk to federal agents or investigators if they contact me?
That's a hard no. What I hear from people all the time is, I have nothing to hide. I have done nothing wrong. So if they want to talk to me, I'm happy to talk to them. And that is a somewhat simplistic and naive view of the world. When you're approached by a law enforcement investigator of any branch, you don't know what they know. You don't know what they want. You don't know who you are to them. You might be a target. You might just be a witness. You might be, someone they're just not sure what to make of. You have no idea what they think of you. And so when they're asking you questions, even if they seem like straightforward questions, they might be looking for one small piece of information. And that's an admission on your part. They may have statements from all kinds of other people. They may have done all kinds of, forensic analysis, and they may have surveillance and things that have nothing to do with you, but you're going to give them this one little piece that ties you into something much bigger. So the simple answer is, rather than wade into all of that, when you're approached, you have no obligation to speak to investigators. You are always free to say, look, I'm not comfortable doing this. I want to speak to a lawyer. My lawyer will reach out to you, and we're going to do this in a more controlled way. The other issue is that when you're speaking to federal investigators, you are opening yourself up to the charge of lying to investigators. And this is a super scary thing, because lying to federal investigators means that you're telling them something that they don't believe is true. And oftentimes, the government's view of the world isn't necessarily 100% black and white correct. There are lots of shades of gray in the way that the world is viewed. So the government is developing a case against a person or a group of people, and they believe that this is what happened, and they have testimony and they have evidence, and it may be that it really truly appears as though that's what actually happened. If you come in and tell them something that is contradicted by evidence that they already have, and they believe that you are intentionally lying to them about this important thing, they can arrest you right then and there for lying to federal investigators. Even if what you're saying is true, you're then going to have to prove that it's true. And I'm not sure anybody's signing up for that when they voluntarily are speaking to investigators, because I didn't do anything wrong and I have nothing to hide.
So zipper your lip and get yourself a lawyer. That's the simple answer.
Simple.
Don't talk to them, and don't sit there and naively think, I've got nothing to hide. Because what your view of the world is and what their view of the world is can be completely different than what you think and completely opposite of what you believe.
And it doesn't mean that at some level you can't cooperate with law enforcement. You can, but you do it in a way that's controlled and that you're not exposed to committing crimes related to the investigation itself.
I know so many criminal defense lawyers who say that before their clients became clients, they did things like this to compromise the very few constitutional rights that we all possess as citizens of this country. The most important one being the right to an attorney, and not far from that is the right to remain silent. So that person may seem really nice, and they're trained to seem really nice. They may seem very friendly. They may seem like they have nothing but your best interests at heart. They don't.
Nobody's a professional witness. We're just not. They don't teach you that in school. Even if you've been in a lot of litigation, or even if you've been, the subject of criminal investigations many, many times over, nobody's a professional witness, but they are professional interrogators. Professional interrogators. That's what they do.
Absolutely.
And one of the things that we see all the time in lots of different aspects of practice is that when people are speaking to someone in authority, there's an element of human nature that you want to please the person asking the question. It's just human nature. You want to do that. And that sort of in a dynamic where you're a lay, untrained witness and they're a professional interrogator looking for specific information that you're not aware of, that lends itself to nothing good happening for you. So follow Evan's advice, call your lawyer. If they can't do it, have him refer you to somebody else, but get a qualified lawyer. If it's appropriate to cooperate, you do that. If it's not, you don't. If you didn't do anything wrong, you shouldn't have anything to worry about, and you're not going to talk yourself out of it.
But don't make that decision yourself when that person shows up at your door or gets you on a phone. Make that decision with a competent advisor advising you on whether you need to make that decision.
Thank you all for joining us. Hope to see you on the next one, which will be coming very soon. And just a reminder on the disclaimer one more time. The information provided on this podcast is for entertainment purposes only and does not constitute legal advice. Please consult with a licensed attorney in your jurisdiction regarding any legal matter you may have. Watching this podcast does not establish an attorney-client relationship with any of the attorneys featured. Take care, everybody.